provide Mr. Eglet the opportunity to try to get one case.
Absolutely, and with Mr. Kemp, you know, which we've tried a lot of cases together.
Okay, we're gonna move on. Next up, page 7 of the calendar, Ginger, Land Van Buren versus Affinity Lifestyles et al. All right, good morning, everyone, and let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff.
Good morning, Your Honor. Robert Eglet for plaintiff Lisa King.
Your Honor, Will Kemp for the Bonnar plaintiffs.
Good morning, Your Honor. Joel Odou on behalf of the water defendants. I see my co-counsel Eric Freeman on Zoom.
Oh, okay. Good morning, sir, on Zoom.
Good morning.
Anyone else checking?
Good morning, Your Honor. Colt Dodrill, Bar 9000, Counsel for Nevada Beverage.
Good morning.
Morning.
Is that everybody? All right, and it appears to me we have plaintiff King's motion to consolidate into the Bonnar matter. And we have a joinder. Is that correct?
Yes,
Okay.
thank you. Good morning. Your Honor, I'd like to start by saying that during this argument, I'll refer to the Affinity Lifestyles and Real Water as a Real Water defendants. And additionally, I'd like to apologize for any inconvenience caused by the court regarding the filing of our reply over the weekend. And we didn't receive defendants' opposition till 4 p.m. And I had my entire firm in Madrid for our annual retreat. So we had to do everything remotely, but I apologize if this caused the court any inconvenience. Essentially, Real Water, as the court knows, I know you've read the briefs, does not really oppose the consolidation on the merits. Instead, they argue that they would be prejudiced by consolidation because they would have to comply with the Bonnar discovery deadlines in King. The Real Water defendants are incorrect for several reasons. The consolidation can be easily accomplished without prejudice to them. First, where consolidation is otherwise warranted, the fact that two actions have differing discovery schedules is only a bar to consolidation. If one action is ready for trial and the other is in its early discovery phase. That is far from the case here. Discovery in King has been ongoing since 2001. Second, most of the Bonnar discovery applies equally to King, and therefore the Real Water defendants would not be prejudiced by Lisa King's addition to the case. Although the deadline for initial disclosures of general expert witnesses has passed, the rebuttal deadline is November 15th. The Real Water defendants should not require any additional general experts as a result of the King's consolidation with Bonnar. This is evidenced by the fact that most of the disclosed experts in the coordinated Real Water cases related to common issues involved in all of the cases, such as the defective Real Water product, the defective ORP meter used in the manufacture, the production of hydrazine and hydrazine toxicity, and general toxicological and epidemiological issues. Further, the Real Water defendants have repeatedly asserted that they will not be contesting liability in King, which will significantly reduce any experts or discovery the Real Water defendants will need. Plaintiffs will not seek the disclosure of any additional general expert witnesses for King either. Therefore, the Real Water defendants already have all the general expert reports that will be disclosed in Bonnar and will not be prejudiced by consolidation with respect to these deadlines. Third, any prejudice the Real Water defendants would suffer in complying with the remaining deadlines can be easily remedied by a brief extension of the deadlines. In their opposition, the Real Water defendants misleadingly list October 28th, 2024 as the deadline for all expert disclosures in Bonnar and failed to mention that the October 28th deadline is only for the disclosure of general expert witnesses. The deadline to disclose case-specific expert witnesses is November 13th, and the rebuttal deadline is December 9th. With the exception of 1 to 2 additional experts, Lisa King has retained all the same case-specific expert witnesses as the Bonnar plaintiffs have retained. Therefore, the work required of the real water defendants in terms of case-specific rebuttal expert disclosures will only marginally increase as a result of the consolidation. Additionally, the deadline to submit expert disclosures in King is December 19th. So a 30-day extension of the November 13th and December 9 Bonnar deadlines with respect to King would allow the real water defendants to submit their case-specific expert reports for King on the same timeline they are already subject to. Likewise, a brief extension of the deadline for any dispositive motions and motions in limine specific to King will cure any prejudice to the real water defendants. Most of the Bonnar motions will address issues common to both cases, and consolidation will not affect defendants' ability to submit these motions by the current deadline. Moreover, the additional motions required for King will be minimal for both parties. Therefore, even an extension of this deadline to 2 weeks after case-specific rebuttal expert disclosures are due for King will allow the real water defendants to complete any motions specific to King without suffering unfair prejudice. Lastly, the real water defendants will not be prejudiced by completing any additional case-specific discovery they need for King before trial begins in Bonnar. I would like to note that the real water defendants could have completed this discovery at any point since the King action was filed in 2021, but they have chosen not to do so. In fact, they have not even responded to any of our written discovery, have not propounded any written discovery on their behalf in 3 years. And the only discovery they have conducted is the deposition of plaintiff Lisa King. Nonetheless, plaintiff will work diligently with the real water defendants to provide any non-duplicative discovery they need in this time frame. In sum, the Bonnar discovery deadlines are not a compelling reason to reject consolidation, and the real water defendants have not demonstrated that they would suffer any prejudice that warrants dismissing the significant efficiencies that consolidation would accomplish. As the court is aware, Mr. Kemp and I have tried many cases together over the last 10 or 15 years. We work very well together, and we work very efficiently together, and we split up the work in the appropriate manner so that we're not duplicating efforts. We have discussed this extensively before bringing this motion, and it's both of our reasoned opinions that at most the addition to Lisa King to the trial would add 2 to 3 hours at most to the actual case, not days or weeks, 2 to 3 hours. And certainly that is not going to burden or overburden the defense with having to get a lot of other lawyers involved or staff involved to get this done. The burden on them is for them to get their discovery done, which they've had 3 years to do and have failed to do. And Lisa King should not be punished for that, for the efficiencies that this case will provide in consolidation. Therefore, plaintiff Lisa King respectfully requests that this honorable court consolidate the King and Bonnar actions for all purposes. Unless you have any questions, Your Honor, I'll sit down.
None at this time, so thank you. Mr. Kemp, yes.
Your Honor, we filed a joinder to this, and the big picture is we've tried 15 plaintiffs, and we got it done last month. It wasn't that big of a deal. So the choice really here is whether you try this case as a singleton for 3 or 4 weeks, or you add it to the other one and get them all done in 3 or 4 weeks. I think it'd probably add, like Mr. Eglet said, an hour and a half to the case. And that's based on the fact that we have King, the testimony for the plaintiffs. You've seen it, Your Honor, 45 minutes typically.
Well, Mr. Kemp, I don't want to cut you off, but when you tell me timelines, I listen. It's kind of like we have
Thank you,
had, because you have a lot of goodwill in that regard. I don't mind
Yeah.
saying it. It's
Yeah, Your Honor, we're not trying to drag things out here.
Yeah.
There is a compelling factor about the King case. She is an autoimmune hepatitis case. The hydrogen in the real water triggered the autoimmune hepatitis. there were three particular women who got autoimmune hepatitis, drinking retail bottles all in March 2018. One was Lisa King, then 28 years old. One was Mrs. Bordnave, who's already in this case, 40 years old. And the other was Layla Cabay, who was 6 years old at the time, that was involved in the Judge Hardy's case, although she was segregated. I bring that up because Real Water has already prepared experts for an autoimmune hepatitis case. They filed the reports in the Cabay case. I already took the deposition of, I don't think this was Real Water's expert, but it was Dr. Brown. He was, I believe, Nevada Beverages expert in that case. Took his deposition on this exact issue, whether or not hydrozine's a trigger for autoimmune hepatitis. That's already been done. So it's not like they have to prepare an expert for a brand new causation theory. They don't. Number one, they did it with Cabay. And number two, presumably they're doing it for Bordnave because their causation reports are due tomorrow. And again, Bordnave is one of the three autoimmune hepatitis cases. And they know our position on this because we filed an opposition to Costco's motion for summary judgment on in the Wren case in front of Judge Hardy that discussed this autoimmune issue at length. We even included the affidavit in there of Dr. Singh, who used to work for the EPA. Now he's in the statistics department at UNLV. And he said that the odds of three women, and again, the three women are Layla Cabay, the 6-year-old, Lisa King, the 28-year-old, and Bordnave, the 40-year-old, all drinking retail bottles of Real Water in March of 2018. The odds of them getting it from anything other than hydrazine is something like 7.8 billion to 1. That's going to be his opinion. They've seen his affidavit already. They'll get his report on Wednesday. So the real issue, I think, is what time they need, if they need to do additional case-specific reports. The case-specific reports are due on November 13th. That would be tomorrow. And again, I'm assuming that they're going to have some expert talking about AIH with regards to Mrs. Bordnave, because that's her claim. So what do they need to review the King medical records? You know, even if they need a week, Your Honor, we would accommodate them. They asked for 2, we wouldn't grow up and die. But I think that's the real issue here, you know, how much they need to do that. And again, I think we're here on November 12th. The trial's not set until, well, it actually hasn't been set because we have a motion for expedited trial. We're on the February 10th stack. So we're expecting to go somewhere on February 17th, February 24th, somewhere in that vein. But there's plenty of time between now and then to accommodate this relatively minor need to add a case-specific expert. And like I've already said, they must already have an AIH case-specific expert. All they need to do is they need to add in Lisa King as a component of it.
Thank you, sir. Mr. Odou.
Thank you, Your Honor. I'm not sure if Mr. Parker wanted to say anything on behalf of Ms. Bordnave. He had checked in.
Did he check in? I don't need to see.
I did check in, Your Honor. Thanks again, Joel, for throwing me out there. But, Your Honor, between Mr. Eglet and Mr. Kemp, I don't believe I have anything else to add. I thought they did a splendid job of informing the court of where we are in this case.
Okay, thank you, sir.
Thank you, Your Honor.
So, Your Honor, as Your Honor is very well aware, this is a part of approximately 27 cases that have been filed in this district, of which there are 16 remaining, and those 16 have been allocated in the 9 trials. The court is very aware that the issue for these cases is medical causation and damages. In particular, the issue for the February 10th trial is medical causation and damages. The problem we have with the consolidation is it's advancing the dates for expert disclosures of Lisa King. Medical experts in the Lisa King case are due on December 19th. We need that time, Your Honor. As Your Honor is very well aware, we've been engaged in trial at this court on a Real Water case through the months of September, and we finished in October. Now we are currently engaged in getting expert disclosures lined up for what the current configuration is for the Bordnave consolidated or Bonnar consolidated trial, which is 14 plaintiffs. You know, getting experts for 14 plaintiffs with complex medical histories was not easy, and we are struggling to meet tomorrow's deadline. We've had experts decline to do the work because of the short deadlines. So to now advance Lisa King's case, into this case and advance the deadline of December 19 to tomorrow or next week or 2 weeks from now is woefully insufficient. It's prejudicial, it's improper. There are at least 9 other cases that the Lisa King case could be consolidated into, including the Cavey case. And I would point out, though, there's a stark difference between the Cavey case where experts have been disclosed, because that's a child with autoimmune hepatitis, and Lisa King, who's an adult. So there's completely different experts. To say that, oh, well, they can just use the expert from Cavey who's already been designated, and the case before Judge Hardy called Cavey is not accurate at all. Moreover, to say that we can use the expert from Andre Bordnave, who is in the current case because she has similar claims, is equally inaccurate. Ms. Bordnave's medical costs today are just over $200,000. Ms. King's medical costs today are approaching $700,000, about 3 times difference in terms of the magnitude of the damages. Everybody's medical conditions are different. As the court's well aware, we've got to look at these plaintiffs individually. Experts have to look at these plaintiffs individually. And so to consolidate Lisa King into the current trial, when there's probably 8 or 9 other choices, and advance the expert disclosures in this case, is prejudicial. And finally, Your Honor, what wasn't addressed that we did address in our opposition was now we're going to have 3 opening statements. Yes, I understand Mr. Parker may do voir dire for all the plaintiffs. He's been very good at condensing his voir dire. We've got it down. We've been pretty efficient in the last 2 trials before Your Honor. But even if that's the case, then plaintiff gets 3 opening statements, 3 closing statements, and 3 rebuttals. And it just becomes overwhelmingly prejudicial to Real Water, who only gets 1 bite at the apple. Yes, some of the dates can be adjusted, but to respond to Mr. Kemp's claim, 2 weeks is not enough to come up with an expert for Lisa King when we thought we had until December 19th. And to advance that expert disclosure date is the problem here. So again, the issue is medical causation and damages, and the issue is prejudice. We've been incredibly efficient about moving these cases along and grouping them together, consolidating cases. We have the Sharapov case consolidated for sometime next year. Certainly if they wanted to put the Lisa King case with the Sharapov case, that we wouldn't object to that. That has way longer discoveries, but yeah, again, the issue isn't written discovery in this case. That's moot. Causation has already been found by this court. It's been conceded by Real Water. The issue is medical damages and medical causation, and advancing those dates is prejudicial, and that's why we've opposed. And really, Your Honor, it's just a question of logistics. Had this motion been brought before the Brown trial, we would have been on plenty of notice to get an expert for Lisa King sooner rather than when we had it set for December 19th. And again, we were looking for experts during the Brown trial for the Bonnar trial. And now we're going to advance that date and throw in Lisa King, and it's just too much. And it's prejudicial. Thank you.
Thank you, sir.
Before I begin, any questions, Your Honor?
What if we hold the December 19th, 2024 date?
That's fine. Your Honor. And I just discussed that with Mr. Kemp. He's fine with pushing the deadline to them.
Yeah, I mean, then there's, yeah, it is what it. Right?
Yeah, and I would point out that the other cases that counsel is talking about are not autoimmune hepatitis hepatitis cases. So it doesn't make sense with coordinating with them. And quite frankly, we have a conference call set this afternoon with Mr. Kemp's expert on this issue for Board Nave, and we believe he's going to be able to act as the expert for Miss King as well. And so that's why I said it's 2 to 3. If he isn't, we're talking about him. We're talking about a life care plan for Miss King, 2 experts as well as Miss King's. Your Honor, a number of the cases that Mr. Kemp and I have tried together have been in front of Your Honor. You know that how efficiently we work together, particularly on these complex medical and pharmaceutical cases. So I just don't see this as an issue. And also, I don't think it should be lost on the court that, they've had 3 years to conduct this discovery. And like I said, they have refused to even respond to our written discovery until the special master, Floyd Hale got involved and essentially finally has ordered them to do that. I don't think we still have the responses yet, but at any rate, this is not going to add a bunch of additional time, a bunch of additional work to defense counsel in this case. The issues are certainly similar. Under the law, this case is perfectly ripe for consolidation. And both of these cases can be prepared efficiently for a trial. And even though, the defendants have not done any discovery, save except, Lisa King's deposition, will cooperate with them in getting them whatever they need. Obviously, we're not going to agree to any duplicate depositions that have already been taken in the case, but anything that's specific to the King case they want to take, we'll get them set up, Your Honor.
All right.
Thank you, Your Honor.
Thank you. Just a couple of comments. I'm not concerned about efficiency. I mean, what did we have in 4 days? How many witnesses testified? 29? Was it 29?
I think we hit 31 this time.
31? Okay, this time. So I'm not really, that's in 4 days. That's still the record. I mean, even I don't mind sharing this with you. Even some of the criminal judges I've talked to, they're amazed at that because that's the pace they go in criminal cases, which is fascinating to me. What I'm going to do, I'm going to grant the motion. I mean, there are common questions of law or fact. I mean, it's really easy when liability is admitted, right? What do you, this medical causation, and we'll hold to the December 19th date. And then from
So the parties
disclosures.
then work on, we'll have to adjust the rebuttal expert deadline and we'll work with plaintiffs' counsel.
Yeah, whatever you agree to, I'm fine.
And I
with
think
it.
maybe January 2nd.
I'll have to talk to the experts to make sure.
Why don't we?
The problem is getting experts working over the holidays. So
I understand.
January 2nd,
That's
probably
when
wouldn't
we're
work.
going to file all the other initials tomorrow.
Yeah, so
Not ours.
For the
That
record,
there's.
Real Water will disclose its experts for the current case prior to the consolidation. Their medical experts tomorrow along with plaintiffs. And then the King expert initial medical disclosure will be on December 19th. The parties will work together for a rebuttal deadline.
That's correct. That's fair, Your Honor.
And that's, is this case going?
Yes,
I have
So,
said,
Your Honor.
okay, well,
Can't provide Mr. Eglet the opportunity to try to one case.
Absolutely. And with Mr. Kemp, which we've tried a lot of cases together, but it's been a number of years since we got the team back together. So you want to.
We have Mr. Parker too. Let's not
we can't forget Mr. Parker.
Yes, well, Mr. Parker and Mr. Kemp and I tried the Actos cases together. So, yeah, we've all worked together.
All right, prepare the order. And is there any need for status checks or anything like that coming up the next?
I don't think so, Your Honor. I think the parties will get together and work out any remaining deadlines that we need to work out.
I think we're okay, Your Honor.
Yeah, that's. And if there's any issues that come up, we can maybe address them at the next motion coming up on December 18th. That's the motion for preferential trial setting.
Yes, sir.
Yes, Your Honor.
Okay, all right. Enjoy your day.
Thank you, Your Honor.